Hi everybody, I'm Grahame Aldous and with me is Laura Elfield, and welcome to the Dekinar on mediation in practice. Let me explain a little bit about ourselves first. I'm a CEDA accredited mediator and a clean leg and PI practitioner, and I'm also the author of a number of chapters about ADR, including the ADR chapter in Kemp Personal Injury Law Practice and Procedure. Laura is also an accredited mediator and is actually a faculty member of the London School of Mediation, so she trains mediators as well as mediating herself. She's also the author of various chapters, including the ADR chapter in the forthcoming DECA publication of clinical negligence claims. So we're going to be talking about mediation in general today and set out some of the things to think about when planning a mediation. And we called it 10 things to consider when thinking about a mediation, which means that what we're going to be doing is thinking about some of the key problems that arise and some of the key benefits that we can get out of mediation. So to start, why mediate? Why bother to mediate when you can have a perfectly good discussion with the other side and settle a case anyway? You can arrange a formal roundtable meeting or joint settlement meeting. Why pay somebody else to come along and act as an intermediary to mediate the proceedings? The reason for that is a mediator brings something else to a discussion, brings a certain objectivity, a certain quality of being the outsider. Sometimes when I'm mediating, I say that I'm a host of the mediation, but a stranger to the dispute, so that I have no interest in getting a particular answer for either party. I'm just there as a mediator to help the parties find their own resolution and reach their own agreement. One of the things about ADR is that I think is sometimes miscalled, really. We refer to it as alternative dispute resolution. There's lots of judicial comment now that that's a misnomer, that it's no longer a form of alternative dispute resolution. And in my view, ADR can now stand for accelerated dispute resolution. It's actually a way of getting to a resolution earlier than you can achieve by waiting to go to trial with all the risks and delays that involves. A major advantage of the mediation is that you keep control of the process. You involve an outsider as a facilitator, but you can always just walk away from it. And you can always have a discussion with the mediator about how it's going, which isn't something you can do with the judge or with the trial. Another advantage of the mediation process is that it does allow the parties to look outside of the litigation. And that can be an enormous benefit all across the board. It doesn't really depend on the nature of the dispute. In a commercial dispute, for example, there may well be a commercial relationship that may or may not continue after the litigation. And it may be that the parties want the commercial relationship to continue, and they don't want the litigation to damage that commercial relationship. Well, a mediator can take that into account and the parties interested in that, in trying to find a resolution. A judge has no interest in that. They just want to answer the question that's in front of them. And so a mediator can look at a case in a much more holistic way than a judge is ever going to want to or need to. But equally, in the sort of cases that Laura and I do as barristers, in a twin leg or a PI case, you can look outside the litigation in things like apologies. You don't get an apology at a trial. You may or may not get something in a judgment that resolves similar issues in a similar way, but you don't get an apology. In a mediation, you can deal with an apology and whether it's a meaningful apology and the terms of an apology and whether it's going to make any difference. In a large number of cases involving fatal accidents, for example, the family will want to know that it's never going to happen again and that steps are being taken. That kind of reassurance can be given in a mediation when simply it can't be done in a trial. And it's difficult to do in a joint settlement meeting without it distorting the process, whereas a facilitator can introduce that and deal with it in a sort of neutral way. It's quite important, I think, that clients feel that they have their say in their day in a mediation. And very often, clients who don't want to go to trial still want to feel that they've been listened to and that their voice has been heard. And the ability to speak to a mediator can give them that sense of being listened to and having their say and their day without the risk and the stress of going to trial. And very often clients who have gone to trial still feel that they haven't really been listened to because they've only been listened to in a very formal process with a very formal way of asking questions. Whereas in a mediation, it can be much more conversational and people can express themselves more freely as they feel they wish to in a safe environment. Very often in a mediation, you might not want your client to say anything direct to the other party, but it can help them to be listened to by a mediator. And then they can go away having settled, but having also been listened to or feeling that they've been listened to in a different way to the way that you might achieve in a JSM or a trial. So those are the positive reasons for deciding to mediate. I'm going to hand over to Laura so that she can deal with the next question, which is, do I have to mediate? Laura.
So yes, do I have to mediate? This could form an entire seminar in itself. There is lots of judicial encouragement to the parties to consider ADR in the round. It's in the preemption protocols. It's part of the overriding objective. It's in the directions questionnaires. And all of us are aware of that first direction in any CCMC that we attend. It used to be called an UNGLI order. It's now just part of the standard directions that the parties are to consider engaging in ADR at an appropriate time. They must prepare a witness statement setting out the reasons that they haven't. I've always thought it's rather unfortunate that the budgeting part of any CCMC deals with ADR at the end, because by that point the judge has usually had enough and thinks he or she has been fair to the parties in terms of the trial, and then you're left trying to argue that ADR is actually probably the most important part of the process. Those are the judicial encouragements. There's also your duty to your client to consider the best way to resolve the dispute. Grahame has dealt with some of the reasons clients like mediation. And of course, it's also a duty to consider how best to control the costs, risks of the litigation. It can often be really beneficial to mediate at an early stage in the process and avoid those escalating costs. And that's something to keep under constant review with your client. Is it compulsory? And that's an exciting and fast developing question. At the moment, it's not compulsory to engage in a JSM. It's not compulsory to mediate, and palsy remains the position. And Grahame's going to deal with some of the costs, sanctions, when parties fail to engage in ADR. But things are moving really, really quickly. Those of you who spotted the case of Lomax and Lomax, that was in 2019. That wasn't a mediation case, but that was where the Court of Appeal upheld an order that one party who didn't want to engage in judicial early neutral evaluation was compelled to. And following Lomax, the High Court in McParland, Sir Geoffrey Voss, said that Lomax inevitably raised the question as to whether or not similar principles applied in relation to mediation. I would encourage you all to read the recent DECA ADR bulletin that was published yesterday, and there we consider the proposals in relation to small claims mediations, which are likely to become compulsory. And also much of what was said at the recent Westminster Policy Forum in March this year about the direction mediation is going. It's coming for us, and I think it's very likely over the next couple of years to become something that is compulsory. But at present, the rule is that that there are only cost sanctions, and Grahame's going to deal with those.
So let's have a brief look at the cost sanctions. As Laura said, the law is still essentially as set out in the case of Halsey and Milton Keynes, that an unreasonable refusal to mediate can be penalised in costs. But things are moving in the direction of a hardening of judicial attitude in favour of mediation. And the reason for that is that the judiciary see that it works. And it's very frustrating as a judge to try a case which cried out for mediation, but the parties just didn't engage in the process of mediation. I can say that because I've tried cases as a judge where mediation should have been attempted. And indeed, I have made adverse costs orders in cases where there was an unreasonable refusal to mediate. And that's not just because I'm a trained mediator. The attitude amongst the judiciary, even those who have never mediated, is now very much in favour of mediation. And so it doesn't necessarily follow that if you refuse to mediate, you will be the subject of an adverse costs order. But if you haven't got a really good reason for refusing mediation, then the chances are that a judge is going to take a dim view of that and to make an adverse costs order, either in terms of denying you some costs or in terms of making you pay costs that you might otherwise not have to pay. And as we all know, the court service is under real pressure. There is huge pressure on judicial time. There's huge pressure on the funding that's available for the court service. And the judicial attitude is becoming that the courts are really there as a last resort to deal with matters that can't be resolved in any other way. And so if you don't do what the judiciary think is the right way of doing it, which is to try and resolve it amongst yourselves, either at a JSM or in a mediation before coming to court, then the court's attitude is likely to be that you've been wasting court time as well as your own, and a cost order, an adverse cost order, will flow. So it's not compulsory, as Laura has said, and it's not definite that an adverse cost order will flow. But if you cannot justify a refusal, the chances are that an adverse cost order will flow if you refuse mediation. So why mediate rather than have a JSM?
So this was one of the questions that we were asked, and we'll deal with it head on here. This slide sets out one of the main reasons, and that's complexity. I don't think it's the only reason, but really the more complex the case, the more a mediator can add. If you're 30 grand apart on a liability admitted claim, then it's difficult to see that you'll need a mediator, difficult to see that you might need a JSM, although I have been to them in those circumstances. But where you've got multiple defendants, a mediator can be the person that's running between the rooms, helping the parties to crystallise their issues. Where you've got multiple jurisdictions, a trained mediator, again, can help to cut through those difficult issues, cut through complexities. But I think those aren't the only cases that are helpful for a mediator rather than a JSM. Also, and Grahame touched on this, where there is sensitivity. If there's been a case involving sexual abuse or intimate gynae claims, bereavement claims, a mediator can add an extra level of sometimes what the client feels is protection. They feel safer if there is a trained neutral involved in the process. And also that trained neutral can look beyond, as Grahame's already touched on, the legal remedies. I think it's also particularly suitable where there's an ongoing relationship of some sort. If the claimant's still employed by the defendant, or even, I mediated a very straightforward neighbour dispute, which on its face was only about who paid for the repairs to a roof, but underneath was about trust between the neighbours. And the mediation helped resolve that. They both went away saying to me, thank you, I'm now going to believe them in future about issues like this. So the mediation resolved much more than simply who was going to pay for the repairs. I think another area is where the parties are entrenched. And we've set out on the slides getting through the legal team. That may be one area of entrenchment, or getting through an entrenched claimant or defendant. Sometimes the mediator, as a trained neutral, can come in and ask the difficult questions, ask the questions that a judge is going to start asking an hour into the trial. Or the mediator can let the parties make concessions without appearing weak. So I think those are the areas to consider mediation over a JSM. If you've got a good mediator, you're never going to, I think, suffer from using a mediator. But the considerations of where a mediator is likely to add most value involve those cases.
So when to mediate, the timing of a mediation, there is no set rule. It's when the time is right. And you can mediate before the issue of proceedings, you can mediate during proceedings, you can mediate before you get to the Court of Appeal, you can mediate while you're in the Court of Appeal. I've been involved in all of mediations in all of those various stages. But essentially, there's no point in having mediation until the parties are ready. And the parties, therefore, need enough information to settle a case. And both sides need to be ready to engage in serious discussion and to be ready to settle. But you also want to try and have a mediation before the costs get out of all proportion, because one of the great advantages of accelerated or alternative dispute resolution is that it can save costs. And if there is going to be a pool of costs that may be incurred, the parties may agree that it's better that that money goes into a settlement sum of damages rather than being spent on costs. And so once the costs have been incurred, it becomes harder to mediate because there's less of a saving to be made. So as early as possible, but once the parties have got enough information to try and settle. And when can that be? What can trigger it? I've long thought that in the sort of standard complex Clineg or PI case, for example, where liability may not be in dispute, you get to the stage where you've got a brain damaged claimant who needs new accommodation, needs a step up in care regime. And for that reason, you end up making an application for an interim payment, or maybe £1 million, maybe £2 million. And at that stage, an awful lot of work has gone into valuing the claim, because you need to do that in order to make your interim payment application. And the reality of it is that the die is going to be cast from then on as to the sort of property that is going to be acquired and the sort of care regime that's going to be in place. Well, that's a really good time to have a serious look at having an overall settlement, rather than spending maybe a year and £200,000 arguing about an interim payment. Why not spend that time, energy and money on having a mediation try and resolve all the issues going forward, or at least all the ones that can be settled at that stage, maybe leaving some other items that will be resolved once the claimant becomes of full age and a better picture can be achieved. But why not take stock at a key point like that and have a mediation? Try and get the litigation running smoothly and dealing with all the issues that can be dealt with at that particular time. But another way of thinking about when to mediate is to it's frozen.
Yeah.
Oh, there we go. We've frozen.
The previous one.
Just bear with us a moment. We just lost control of the screen, but we will get there.
Slightly spoiling the surprise.
Yeah, there we go. There we go.
With your quick slides.
We've all had the cases where you get that panic feeling. This is a case that's run out of control. And very often, when you get that feeling, you assume that you're the only party who's got that feeling. But very often, you find that actually both parties have got a similar feeling that the case has got out of control, either because some evidence has blown up on one side or the other, or it's blown up for both sides. And as Laura said, one of the best ways of determining whether a case is fit for mediation is looking at its complexity. The more complex a case is, strangely enough, the better it is for mediation, because a mediator can cut through a lot of the complexities. And a classic example of that is where you've got a cross-border dispute with various jurisdictions. If you can spend an awful lot of time, energy and money on arguing which jurisdiction you should bring the claim in. And it may be a given that some jurisdiction will end up hearing the case. And so why not cut through the issue of which jurisdiction and try and mediate it with a view to reaching a settlement that maybe doesn't ever determine which was the appropriate jurisdiction, but reaches a settlement that both sides can be happy with. So those cases that bring on that kind of dreadful woe, strange enough, those are the ones where it really can help to get a mediator on board. And you may be toiling away trying to lift your case out of the water and get it back onto dry land, and you may be doing really quite well, and then suddenly things begin to go wrong. And sometimes in those cases, you do need to get a bit of help. Now, I'm not saying that mediators are bigger cranes than litigators, but we all have cases where it can help just to get a fresh view come in as an independent facilitator to help both parties to see through the complexities of a case. So let's have a look at how we set up that mediator, how we get hold of them and set it up. So Laura.
So it's much easier than you think. I mean, if it's a clear neg claim against the NHS, then you've got to use one of their recommended providers, and they will have a couple of panels of mediators. You will need to choose usually 3, and then those chosen ones go back and forth until you can agree. You can simply go direct to a barrister or a solicitor. So we have a whole list of mediators. You can ring up the clerks and ask which one would be most suitable. You then really simply need to agree the date and the venue. I wanted actually to take this moment to dispel some myths. Quite often when these lists of names go around, you've selected 3 mediators, either by going to chambers or to a solicitor's firm or to a provider. The parties then start to argue, oh, they're too claimant-minded or they're too defendant-minded. Or sometimes we have emails going around chambers, do you know any good mediators? And I'll say, yes, me, or we've got lots of good ones in chambers. And people say, oh, I don't think my opponent would be very happy to have someone from chambers. And it's worth remembering that the mediator is supposed to be a neutral person. And when I train mediators, I tell mediators to consider themselves the ghost in the room. They are the messenger, they are the facilitator, but they shouldn't be getting overly involved if they're a good mediator. In terms of how you think about approaching that mediation, and we'll come on a bit more to preparation, but it really is like a combination of a CMC and a JSM, because once you've selected the mediator, they will be telling you what to do from there on in. They will say, well, when I mediate, I want a bundle. I want a paginated bundle of the witness statements, the medical reports, the schedule. I want to see the costs budgets. So you'll be preparing in that way. But also, if you are an advocate or a solicitor, you'll be preparing to know your case inside out, just as if you are attempting a JSM. And then once you've set it up, you have to think about
you have to think about who pays for it. Yeah. Ordinarily, the parties will split the cost, at least initially, between them. Sometimes an insurer or one party will agree to pay a mediator, but the ordinary arrangement is that the parties split the cost between them. And a mediator, a good mediator, will want to be paid in advance of the mediation. And I think that is a sensible idea, because it removes any problem that the mediator has a commercial interest because they want one party to pay them rather than the other. The mediator's been paid, they can be entirely neutral. And also it shows commitment on the part of all the parties to the mediation if they have put their hand in their pocket and paid a share of the mediation. And one of the questions that we've had coming in is, how can you stop a party from turning up to a mediation and not taking it seriously? Well, one way is to get them to put their hand in their pocket and pay a share of the mediator's fee. Because if they're going to waste time, they might as well just waste time at a JSM rather than paying a mediator. I think if all parties are prepared to go through the process of arranging mediation and funding a mediator, that shows a commitment and a degree of goodwill. Doesn't necessarily mean that they're going to settle, or that they're going to settle at a figure that the other party will be happy with and will accept. So it's not a guarantee of achieving settlement, but it does show commitment and goodwill to a mediation. And but that's just the starter, because part of the mediation, and often a large part of the mediation, will be who's going to pay the costs of the litigation, including the costs of the mediation. And when I first was accredited by CEDA, the standard CEDA mediation agreement provided for the parties to pay their own costs of the mediation and to split the cost of the mediator. And it didn't say any more than that. And that created a problem for people involved in litigation. And as a result of pressure from people like me and a number of others, CEDA have a number of alternative mediation agreements now. And they have a mediation agreement which provides for the costs of the mediation and the mediator to be costs in proceedings. And so what you're looking for, and it's worth checking the mediation agreement. The mediator will normally provide a mediation agreement, but whoever sends it is worth checking it. What you're looking for is something that doesn't just say the parties agree to pay their own costs of the mediation, but adds those costs and the cost of the mediator shall be costs in the case of the proceedings unless otherwise agreed. And similarly, if there's a provision that says something like no party to the mediation shall make any reference to the mediation in court proceedings, you might want to add in, save for the purposes of any assessment of costs or as ordered by the court, so that you can include in your cost bill the cost of mediation, and you can make reference to it for the purposes of the assessment of costs. And that's a point about the mediation agreement. There are a lot of standard mediation agreements, but don't take them as read, don't take them as inflexible. The parties can and should discuss the basis of the mediation and the basis that they're happy with, and should agree the mediation agreement between them and the mediator. And the mediator will be perfectly happy if the parties come to their own agreement as to their own costs and their own cost provisions, so long as the mediator is getting paid. The mediator won't mind. But so don't just sign the mediation agreement without reading it and checking that it does say what you think it says and what you need it to say. One of the other questions that we've been asked, and this was from Gareth Jenkins, who I see is from the Government Legal Department, so it doesn't astonish me that the question from that angle is, do the speakers think that mediation is overpriced? Well, I have to say I don't think mediators are overpriced. But the answer, I think, is no. One of the issues, I think, is that perhaps mediation is underpriced and undervalued. Personally, I don't do NHS resolution mediations, and I won't be on the panel because I don't think the remuneration is high enough, and I don't think, as a result, that the quality of mediation is high enough. When I do a mediation, I engage fully with it and I put a lot of work into it. The NHSR mediation scheme, in my view, does not fund that and does not encourage it. And I have had NHSR mediations as counsel where I have felt that the mediator was just going through the motions rather than doing the job of the mediator. And so I think mediation is like life. The more you put into it, the more you'll get out of it. If you value the mediation process and you are prepared to pay for a mediator who's prepared to work hard at it, then you will get more out of the mediation than you will by trying to skimp it. So do I think that mediation is overpriced? I don't think it's valued enough. And actually, so long as you know what you are paying for, then sometimes you get more value for money by investing more in the process and trying to skip on it. So that's the question of who pays. How do we then prepare?
So I was actually, I'm going to speak about that, but I also wanted to pick up on the question that you had partially answered about how to avoid the other party attending mediation because of the consequences of refusing, but with no real intention of settling. Because one of the things you might have to prepare the client for is a non-resolution. But to deal with that question first, one of the other things in the mediation agreement, apart from provisions about payment, is usually a provision about attending good faith. And I think that can really focus the parties' minds. And if I'm a mediator, that might be something that I remind parties gently about at the start. The second thing to say about that is that both as barrister and as mediator, I've had mediations where I thought that maybe the parties were just going to go through the motions, but usually going through those motions and attending them in itself generates a sort of movement towards settlement, and they have resolved ultimately. And I also wanted to just deal with a really interesting case. When I was updating the Neg ADR chapter, there's lots of press about it, although I couldn't find the name of the case. But at the end of December 21, Master Davidson, clearly dealing with parties who did not trust each other at all in the commercial courts, made what's thought to be the first ever order for compulsory mediation. Now it's not as startling as all that, because he was asked to do so by consent. But the more interesting part of the order, in particular with reference to the question asked, is that he ordered, again by consent, the parties to meaningfully engage in the mediation process in a genuine attempt to reach a settlement of the proceedings. And the parties agreed that they would be able to give evidence of each other's conduct, effectively waiving privilege, as to the issue of costs. And as to the issue of failure to engage reasonably or otherwise. I don't know how that case ended up. Hopefully it resolved at the mediation, which is why we didn't hear anything further about it. But there are ways to try to ensure that the other side attends. But as I say, they do have to sign, everyone has to sign to say that they are attending good faith. Now, coming back to the slides, how do I prepare for the mediation? Well, you want to prepare the client first. I always think it's a good idea to have a con before the day of the mediation, so that you can talk through in a much calmer atmosphere the range of potential outcomes, the format of the mediation. You can ask the client questions. Do you want to be in a room with the other party? Do you want to say anything? Or do you want the lawyers and the mediator to deal with this? If you are the advocate or you're the solicitor preparing yourself, well, you prepare as if for a JSM. You know your case inside out, and you know everything, including the costs of proceeding forward to trial. That could be one of the most important negotiation points. Help the mediator, and this is something I struggle with. I was mediated by someone who trained me at the London School of Mediation. I trust her implicitly, but I struggled as advocate to trust her when she was mediating. I didn't tell her that we were going to walk away if we didn't settle the case. It didn't matter. We got to a resolution. But I think there is it's really useful to try to understand that the mediator is there as a trade neutral, and help them as much as you can. So in terms of preparing for mediation, you should expect to hear from your mediator. I always call the participants before the mediation and chat through any issues, and that's your opportunity. Tell the mediator, D2's solicitor is holding up this process. There's been a breakdown in relations between the solicitors. D1's reputation is on the line. My client's a nightmare. I've tried advising and I can't get through. Those are things which I think it's all right to tell the mediator in absolute confidence as a way to try to get to a resolution. That's the chat with the mediator. And then what do you need if you are attending the mediation as representative? You need to make sure that you've got authority to settle. So as mediator, that's the first thing you will ask: has everyone got authority to settle? And if other parties only have authority up to a certain amount, well, you need to know that there's going to be someone on the phone that they can contact if things go above that. You want details of costs. I like to have the budgets. You need accrued details of interim payments, all of the things that you will require in order to execute a binding settlement agreement at the conclusion of the mediation. I think Grahame's going to deal with on the day. If we can get this to, we're not doing very well, but slides here. Should we try this next?
Yeah.
That's not working either. It's every time we go on the Q&A, it's somehow so we just went back.
Right, what do we need to think about on the day? The mediator will normally ask you to do a written position statement before the mediation. Sometimes that's for the eyes of the mediator alone. Sometimes you exchange position statements. That's a matter for negotiation with the mediator, with the other parties. But that's a statement in advance. But very often the mediator will start with sometimes rather grandly referred to as a plenary session, where everybody is in the same room, a genuine round table meeting. That's often an advantage for the mediator, because the mediator can then explain the ground rules to everybody involved in the mediation, so that everybody has heard the same explanation about the ground rules, about the role of the mediator, and what to expect and what not to expect from the mediator. And at that stage, the mediator will very often ask the parties to consider whether they want to make an opening position statement, an oral opening. That is not the same as an oral opening at trial. And you need to think in advance about what you're going to say and what message you want to send to the mediator and what message you want to send to the other side in your opening position statement. It's an important thing to remember that although the mediation is confidential, and if the case doesn't settle, the other side can't refer to what you've said in the mediation at trial, just as you can't refer to what the other side has said in the mediation at trial. But things that you say in a mediation can't be unsaid. So the other side will know, if you don't settle, what you said in the mediation, and can bear that in mind in the way that they prepare for trial and the way that they deal with the matter at trial. And one of the questions that we've had in, I see, is a question about how to deal with concessions that are made during the course of a mediation. Well, until a mediation has reached a final agreement and it's been rendered into writing, they are simply concessions that are made without prejudice. So you shouldn't assume that the same concessions will be made at trial, nor should you assume that you've got to make the same concession yourself at trial that you might have been prepared to make or you indicated you might make at a mediation. But once again, you might not be bound by a concession that you've offered in a mediation, but the other side will know that you were prepared to make that concession and may draw their own conclusions as to why you were prepared to make that concession. So think through the way in which you want to make concessions, the timing in which you want to make concessions, and the terms in which you want to make concessions, and the explanations you want to give for them. You do need to have thought, where do we want to get to? It's very easy to get caught up in the dynamics of a mediation. Just as it is very easy to get caught up in the dynamics of a trial and to lose objectivity. So it's good to have thought in advance, where do we want to get to? And that can work both ways. Sometimes you can just get very stubborn and over-optimistic in the dynamics of a mediation. And it's then useful to think back to when you're thinking about the case in the cold light of day a week earlier. What was your assessment? What was reasonable when you were thinking about the case then? And are you still thinking about it in that same objective way, or have you got carried away with it? But similarly, what's your bottom line? What would you walk away from? Because the golden rule of all settlements, if you want to settle, you need to prepare to fight. And if you're going to have meaningful settlement discussions, you need to be prepared to walk away, and you need to have prepared the client for that. And also, what do you tell the mediator? You need to think through what it is you're prepared to share with the mediator and when you're prepared to share it with the mediator. I sometimes put it rather crudely that your task is to make the mediator think that you're the most reasonable person in the room, especially when you're being unreasonable. But you will get the best out of the mediator by convincing the mediator that you're the reasonable grown-up in the dispute. And so to that extent, it's about building the rapport with the mediator so the mediator can use that to help your settlement, your objectives to prosper with the other side. Bear in mind that, like a joint settlement meeting, a mediator can be very wary. And it can be very wearing, particularly for the client, who may have, despite everything you've said to them, they may have lost sleep the night before. They may be tense. The temptation for them, because very often in a mediation, you've got a room full of coffee and chocolate biscuits. They can get over-sugared, over-caffeinated, overhyped. So you do need to pace yourself and the client. I will sometimes either send the client out for a walk in the fresh air, or I'll take the client out for a walk in the fresh air. And I've before now gone for a walk in the Temple Gardens during a mediation, just so that the client can keep grounded and not get panic struck or claustrophobic in a mediation. You do need to think about pacing yourself and making it easy for the client to stay in touch with the dispute and where the settlement's got to, so that they don't end up feeling pressured into a settlement or over-disappointed if they're prepared to walk away from something. It's a good way of bringing the client with you along the road to hopefully towards a settlement.
I'm scared to come back on this issue of the opening positioning statement. I was recently training mediators at the London School of Mediation, and it's become quite a hot topic as to whether or not you train mediators to request an opening positioning statement, because it can really entrench the parties at the outset. And so there's how do you do that while at the same time discouraging the barristers if they're there from grandstanding and then digging people in. So whether you're the mediator or indeed whether you're the person, whether you're the representative, that opening positioning statement has to be pitched really carefully, especially if what you want to do is try to achieve a settlement rather than grandstand and push the other side into more of a corner than they already were in.
Yeah, as with mediation, as with settlement meetings, you've got to remember that the other party makes an offer not because you wanted to make an offer, but because they want to make the offer. So the task is to get them to think that it's in their interest to make the offer you want them to make, and to help the mediator to convince the other side that that's the offer they want to make. So,
in terms of pacing, well, I think that's something which goes to my next slide, if we can get it. Yes. No. There we are. So, remote or in person, well, most of the time now, mediations, and I think rather sadly, are going to be remote. That's just the way everything is going. I still think better in person. It's all about the human process. It's about the warmth. It's about the rapport. It's about building relationships. It's about approaching a settlement. All of that is done best face to face. However, you shouldn't let perfection be the enemy of the good. So remote mediations can still work, and they can sometimes help if you've got a client who really doesn't want to be in the same building as the other side, or they are particularly stressed and anxious. They can pace themselves more if they are at home. The other way to do it, which can often be the happy compromise, is that you get your team together and you can deal remotely with the other side, but at least you have the human element between yourself and your team, which I think always helps, if possible, to send clients away happier.
Yeah, a bit like webinars, really.
Yes.
I think most of us prefer to do these things in person, but webinars work because it allows everybody to participate far more easily than it would be to get everyone in one place for an old-fashioned seminar on the way that we used to do them. And also, a Decanar allows people to put questions in the Q&A box, which we've been following from, as you'll have gathered from some of the questions that we've been dealing with. We've also had a question in there about how to become a mediator, which is a good question because it's not actually straightforward. There are a number of training opportunities available for mediation. My view, for what it's worth, is the same as I was saying about the value of paying mediators. It's worth getting value for money, and that can be worth paying more for a decent training course than just going for the cheapest training course that you can find. When I trained, a CEDA training was regarded as market leader training, so I went for that, and it was about 4 days. It was quite expensive, and I turned up thinking I've been settling cases for ages. You know, what can it possibly teach me? And the answer was quite a lot, and I benefited enormously, both as a potential mediator and actually as a practicing barrister, from having gone through the mediation training. And I thought it was worth the money. Laura, as you've heard, is a faculty member of the London School of Mediation, so another quality product. In my view, it's worth investing. If you're going to do it at all, do it properly. The problem then is, how on earth do you get the experience in order to become a mediator? Because most of the schemes require you to have done some mediations. How do you do mediations if you haven't done any mediations before? It becomes a problem. There are a number of schemes. In my day, the Central London County Court scheme operated a sort of cheap, cheerful way of doing mediation. And so I cut my teeth on doing some of those, and the most extraordinary disputes that I ended up mediating. The great range of mediation, which was great fun. And I can remember one of them in particular where the parties were really at daggers drawn in the litigation. And they settled it at the mediation. And I can remember the astonishment on one of the solicitors' faces when they said to me at the end, "I never believed we could settle this case." And we just have. And in a sense, that's what's got me hooked on mediation, because it works and is really satisfying when it works. And you allow parties to come to an agreement when they had no clue that they could get to that stage, but somehow you managed to get them to it. And that's what makes it a worthwhile thing to do. So I do encourage people to train as mediators. I do encourage people to become mediators, but it's not an easy process, because you do need to find some other way of getting the initial experience so that you can hold yourself out as an experienced mediator. Laura, anything you want to add on that question?
Well, I mean, really, I think to reiterate that you do the training, and even if you end up not mediating a single case, it's so worthwhile. I thought as a barrister, I knew a lot about interacting with clients and principled negotiation, the art of listening, and really it was invaluable just to have to refresh my skills, and it's why I enjoyed the teaching so much and assessing mediators, because I refresh and refresh again and again all of those soft skills which go towards helping you be a good lawyer as well as a mediator.
Okay, I don't see any other Q&A questions coming in the Q&A box, so let's begin to wrap up. Just so that you know, After this, you will be getting emailed through to you copies of the slides, a link to the recording so that you can have a look at it again if you've missed something or you want to review it. And also you will be getting the DECA guide to mediation by way of a handout, which will have more of the sort of things that we've been talking about. And if you want more, you can see my chapter in Kemp & Kemp Personal Injury Law Practice Procedure, or when it comes out in due course, which hopefully won't be long, the next edition of the DECA Guide to Clinical Negligence Claims, where Laura has written the chapter for that. This is the beginning of a series of decograms in relation to ADR. There'll be another one in the autumn, which will be a more in-depth look at the pitfalls of failure to mediate. And so look out for that as a decanar in the autumn, and there'll be decanars on other topics that I'm sure you'll be hearing about in due course. So I hope that's been helpful, and I hope we've answered the questions that people have lobbed at us. And we look forward to seeing you at future decanars.